G'day there guys, it's your Aussie Hubby Markee, back at it again with another episode of r/Legal Advice. Now I know you guys love legal advice and I have no clue about law, so let's start this journey. I hope you guys enjoy it. Smash that like button, chuck a prawn on the barbie, and let's get to it. Posted by user Visible Split, titled, Purchased Abandoned Foreclosure, What to Do with Furniture and Vehicles, in Texas. So I just purchased a foreclosure with the intention of eventually residing there. Property appears to have been abandoned for at least 2 years. Upon receipt of deed, around 30 days, we intend to proceed with formal eviction. However, there is a lot of furniture and 3 vehicles on property. We have no means to find previous owner. Neighbors have tried for years. Do we need to hold on to property for 30 days after eviction, indefinitely, or simply allow sheriff's office to take it to the curb? Why would the sheriff's offices move anything? That is not their job. I suggested dumpster. The cars will be harder to get rid of without a title. Well, that was the sheriff office's suggestion at the auction. Not to physically move it, but to be there as a standby if we remove anything from the house. He said they often do that occasionally for foreclosures or evictions when property of value is left behind. There are companies that contract with city and law enforcement to take on legal proceeding and liability in exchange for all property. Officers are required for move-out. Update to purchased abandoned foreclosure, Texas. I had low interest in my initial post, but just wanted to give an update in case it could help anyone in the future. My first lesson learned is a common piece of advice here: get a lawyer. I found a local attorney who offered to meet me for a free consult, with the understanding if we stretched past 20 to 30 minutes, I would pay. We spoke over an hour, but he said he didn't want to charge since it was such a refreshing change from his typical landlord/tenant disputes. We talked about 1. Property laws, 2. How those various laws apply to my situation, and 3. Typical enforcement. My initial approach fell apart at 2. He recommended not proceeding with eviction as I had planned, as it was essentially an acknowledgement of residency. Instead, I put up a notice of abandonment for 30 days. My lawyer also advised I could continue cleaning out my house in the meantime as it presented a clear health hazard. After 30 days, I made a big dent in the filth, but the house was still jam-packed, and the thought of arranging sales or pickup of all the furnishings and decor was overwhelming. No estate or garage sales are allowed in my city. I ended up contracting with a liquidation company that came in and carted everything off. They sold everything online, and I received around 40% after fees and such. The $1,700 roughly covered my costs for cleanup, supplies, and such. I filled multiple mini dumpsters. I have since learned that the previous owner struggled with alcoholism and mental illness, and she left around 3 years ago. She has an online blog, but her last entry was nearly a year ago, and doesn't mention where she was at the time. I kept a couple of boxes of family photos, mementos, and her son's armed forces ring, but my lawyer suggested I wait to contact, as there are villains in these cases. The first villain is the situation, whether it is a mental illness, addiction, or simply market circumstances that lead to foreclosure. The second villain is the bank that forecloses. The third is the buyer, who is perceived to have gotten a steal, both literally and figuratively. This is the person most easily targeted for blame. Since I'm moving in alone with school-aged kids, he recommended I get the house secured with perhaps some monitoring before I consider contacting previous owner to return items. He suggested she might eventually sue me for the cost of items we removed from the home. There was so much, and many more auction receipts for diamonds, figurines, and artwork that we believed was removed from the home at some point. However, he said we should be legally covered due to documented conditions and ownership of property. After nearly 3 years of no AC in the southern US and burst pipes, nothing in the home was in pristine condition anyway. Per this sub, he mentioned that anyone can sue for anything, but she would need to pay a lawyer up front to take her case, or just figure out remote small claim filings for herself. If this came to pass, I could pay him $225 an hour at 7.5-minute increments to mail letters and responses he already has fast templates for on his PC. In other words, it would be more expensive for her than it would be worth. The only weird loose end was the cars. He said this was the most legally clear-cut issue, but didn't work out with the number 3 above. He said we should be able to call the city centre and have cars towed no problem. However, the sheriff deputy who came out said there was nothing that he could do, as the county would not let them call tows due to potential liability. We still didn't have final deed of ownership at the time, so one tow service was skittish. However, we did find a service that ended up picking up all 3 cars, and I imagine they were auctioned or junked. I'm still receiving lots of collection letters here and there, and even a repo drive-by for a vehicle that was not here. But we have finished restoring the home in record time, and are all moved in. Hope this may help someone at some point in the future. Posted by user Banana Fugu. Titled, My 27 female, apartment's handyman, 60 male-ish, has been watching me through my window. What right do I have to get him to stop? This is in Washington State. I've lived alone in my micro-studio apartment in Washington State for just over 3 years now. The handyman, John, who lives in the building too, has made me uncomfortable since I moved in. A year and a half ago, after hearing he had sexually harassed a former tenant, I spoke to the office about his behavior. I was told he's worked here for over a decade, and they've never had any complaints, so nothing was done. But in the 3 months following my complaint, John inspected my apartment 4 times, to check for fire alarms twice, to check smoke alarm, and to spray their bugs were their reasons. I don't make maintenance requests as to avoid having him in my apartment and being alone with John, but today I had an urgent maintenance issue. As he works, we talk about what strange times we're in under the pandemic, and I mention how my COVID-19 symptoms hit me hard back in March. I had multiple symptoms but no cough, so I was unable to receive a test. He said he watches me through his window and could really tell how sick I was. I was as polite as possible to keep the situation calm and get him out ASAP. Now I really am concerned. I feel extremely violated and unsafe. He's been watching me so close that he knew I was sick. That's more than an accidental glance into a neighbor's window. I've closed my blinds permanently today and am going to stay with my dad for the foreseeable future. What can I do to prevent this from happening again? I'm concerned the office will not care. Do I file a police report? Do I have any rights? I really don't know where to go from here. So any insights will be so very appreciated. I am not a lawyer. If he were outside peeking through your window, that would be illegal. But if he can just see into your apartment from his window, not sure that you would have a case in that in your apartment complex you could not expect privacy with an open window view. It's up to you to pull curtains and blinds if you want privacy. On another note, if you get a creepy vibe from him and he makes excuses to access your apartment, I would check your fire alarms and shower heads/vents for a camera. If there was a camera anywhere planted in your apartment, this is 100% illegal. Whoa, I didn't even think about the fact that he could have cameras. I'll be checking my apartment shortly. Document the camera if you find it and set up your own camera to record him coming back in for his, probably switching out memory cards or something. Stronger evidence for the police having this. Or just coming back in general. He might be using the camera to watch, but if he's willing to set up a cam, he could also be the type to be coming in, going through her things, potentially even taking stuff or doing stuff. I'll leave stuff to the imagination. It might also be worthwhile to request maintenance/access logs from management periodically. Once OP has her own camera in place, the first time her unit is accessed and it doesn't correspond to the logs, there would be some explaining to do. I'd recommend at least 2 cameras, one covering the entrance and one covering the bedroom. The entrance will give proof of access, but if it doesn't show the kitchen, bathroom, thermostat, etc., he could make the argument that he was simply performing maintenance. A second in the bedroom is key, if privacy and security of footage is a concern, and it should be if the camera isn't 100% closed circuit/air gapped, pointed at the closet and dresser, as that's what he'd likely be interested in. If OP's not comfortable with that because she'd be captured on the footage, at last, place the cam somewhere it can catch her entry to the bedroom. There's very little in terms of maintenance that is needed in most apartment bedrooms, so there's very little reason for a maintenance person to be in there. SS412 says, while it may also help your own situation, I would recommend asking management what the process is to file a formal complaint for the sake of the next tenant in a similar situation. The response of, "We've never had a complaint," may be strategic. Entities like to have an incentive to talk tenants out of filing formal complaints. Further, tenants may not even realize they aren't filing a formal complaint by having a conversation with management. It may be as innocent as wanting to avoid work and paperwork, or it could be more nefarious, such as continuing to cover up bad behavior and/or liability, or being able to inflate safety numbers to prospective tenants if asked. You having a conversation may not meet their criteria of a complaint. It's possible this is a well-known issue with this guy, and they've had similar conversations with 5 tenants before you, but they can make that statement to you because they've just been successful in de-escalating it from reaching the level of a formal complaint. Right now, if something were to happen and the police got involved, they could say, yes, she raised it with us but didn't file a complaint. And if a few years pass and something happens to another tenant, they may not even get that. Personnel change and conversations are forgotten over time. But if a complaint is formalized, it goes on file and they can't truthfully make that statement anymore. And if law enforcement gets involved, it could result in obstructing an investigation charges if represent that to the cops. I just sent off an email asking about how to file a complaint. I didn't realize that telling them about the situation was different than a formal complaint. Even if they tell you the conversation is sufficient, I'd still send them a letter or an email detailing the specifics of what he's done that you view as inappropriate, and your resulting concerns as others have provided guidance for. God forbid something happen that requires this to escalate to either civil or criminal legal system, but if it does, you don't want it to turn into a he said, she said, or I don't remember. Your headline says he watches you through your window, but your description said he saw you through his window. Does he live nearby and have windows that face you? That's a lot less creepy than if he were hiding in a bush outside your window. He has told me in the past that he looks for me, which at the time I interpreted as he looks for me as he's walking around working on the building. Yesterday he said he watches me through his window, his words not mine. That's just as creepy to me as hiding in a bush to me, as he can do that any time and not look suspicious. Yeah, but unfortunately it may not be as actionable. If you tell the police that your neighbor watches you through your window, they'll just shrug. It would be tough to even qualify that as harassment. And there's an update in the post. I have filed an official complaint, a police report, and an anti-harassment order for no contact or surveillance. I searched my apartment, but did not find any noticeable cameras. I will be investing in a nanny camera for when I am not home. If my anti-harassment order gets approved, I will also be changing the locks. Thank you for all your advice. I'm glad this one ended well. I'm happy for them. Posted by user HIPAA Violator, titled, "Patient hit my car and didn't stay. Am I violating HIPAA if I give them away?" That rhymed, I like it. Hello. So I'm an urgent care PA and I'm in an unusual situation. Yesterday I had a patient come into my clinic for a cold. They got upset when I told them they didn't need antibiotics and they left angrily. I didn't witness the accident. I was with another patient. However, my front desk staff saw the aftermath. According to the front office, the patient got into their car, squealed the tires, and peeled out of the parking lot, lost control, and hit my car. It certainly didn't know it was my car. Regardless, they got out of their car, inspected the damage, and then quickly left. Now, we know who it was because they were a patient, but by telling the police who they are and how we know them, is that a violation of HIPAA? The guy wasn't very pleasant, and if it is a violation of HIPAA, I can easily see him causing me a huge headache over it. I'd rather pay my deductible than deal with HIPAA nonsense. I've already left a message for our risk management team, but I haven't heard back, and so here I sit with you, my Reddit attorneys. There is a specific exception for reporting suspected crime. You guys can find this link here. There are certain cases where HIPAA-covered entities may disclose PHI to law enforcement. Some exceptions include cases where you are reporting suspected child abuse and neglect. you are legally obligated to report to the PHI to law enforcement, e.g. by court order or legal statute. You are reporting the death of an individual when it is suspected that the death resulted from criminal activity. You are reporting to an off-site medical emergency, and it's necessary for you to alert law enforcement of criminal activity related to the medical emergency. You need to disclose the PHI to authorized federal officials as part of an intelligence, counterintelligence, or other national security emergency and investigation. You are reporting evidence of a crime that occurred on the covered entity's premises, or you are responding to a law enforcement request for PHI related to identifying a suspect, fugitive, or material witness of a crime. Note: some information can only be released under court order, warrant, or a written administrative request. The last two are probably the most relevant to your situation. It's not a violation of HIPAA. You don't have to disclose his medical information. You don't even have to tell anyone he's a patient of yours. Just that you know the guy, and your front office saw him hit your car. It's only a HIPAA violation if you disclose health information. The HIPAA privacy rule establishes national standards to protect individuals' medical records and other personal health information, and applies to health plans, healthcare clearinghouses, and other healthcare providers that conduct certain healthcare transactions electronically. The rule requires appropriate safeguards to protect the privacy of personal health information and sets limits and conditions on the uses and disclosures that may be made of such information without patient authorization. The rule also gives patients the right over their health information, including rights to examine and obtain a copy of their health records and to request corrections. This is the most correct answer. PII and PHI are not the same thing, although the former is a component of the latter. This is fully correct, not a lawyer. You can call and simply say someone hit your car, and that you know who did it. No covered information in that statement. HIPAA is to protect against disclosure of someone's personal health information, which you can entirely avoid in reporting this incident to avoid implicating HIPAA. Your first stops for an answer should be the agency that regulates ethics and standards of conduct in your profession, and any HIPAA or risk management advisor employed by your workplace. Having said that, a car accident is not directly healthcare related. Things that are not sensitive personal information obtained from your practice, like address, telephone number, and social security number, would best be not reported or even accessed by you. The patient's name and license plate number are not protected, however. Reporting an accident is a civil and criminal matter. There are exceptions for litigation and crime reporting. A mental health professional, for instance, is usually statutorily required to report threats against themselves or other persons without getting in trouble with HIPAA. I hope you guys can take something away from all this advice. I know it's long, but it's all really good, substantial advice, and if you don't agree with that, that's fine. Everyone's entitled to their opinions down in the comments. Update: Arizona. Patient hit my car and didn't stay. Am I violating HIPAA if I give them away? It wasn't a super popular post, but I want to thank everyone who responded and those who sent PMs. Risk Management finally got back to me yesterday, and even though they do not believe it will violate HIPAA to do so, they do not want me to report him to the police. The estimates to fix my car are around $6,000, which they offered to pay as well as pay for a rental car. I figured they figured it's cheaper to pay to fix my car than to deal with this guy. So not a very satisfying ending for those hoping for justice. Alright, our next one doesn't have an ending, but tree law. Posted by user Mercanty Baby. Titled, "My tenant cut down trees in my yard, including my apple tree. Gah! We live in BC, Canada. Oh, it's even better. It's one of those trouble states. Why is the worst stuff always in Canada? So here's the story. Renters moved in May 15. They asked that we take the house off the market. They will sign a 2-year lease and pay $2,000 a month, $100 more than what we're asking for. Immediately, they were late paying rent, and since then, have not paid rent on time once. Numerous messages every month with excuses as to why rent couldn't be paid on time. June 7th, he asked me to pay someone to take care of the yard because they couldn't afford a lawnmower. I reminded them that it was in the rental agreement that they care for the yard because we are 10 hours away and that we need a somewhat self-sufficient tenant. More months of late rent and complaints about such small issues, which we immediately attended to by sending someone in. Furnace filter needed changing, toilet ring needed replacing in both bathrooms, and dryer needed to be replaced. July 21. He messages me about pruning the trees and cutting and getting rid of them. I clearly stated in text that he was not allowed to cut the trees down. September 14. We have friends come visit and tell us our grass is about 3 foot tall. So I send this message to my tenants. Hey Chris, could you please mow the lawn or at least pay someone to mow and clean it up? Just got a call from a neighbor concerned that the place isn't being cared for. Said the lawn was out of control. He proceeds to tramp that the yard has been a disaster since he moved in the spring and that he shouldn't have to do a dump run for the garbage in the yard. The garbage, I explained, were painted decorative tires for growing potatoes with the garden, and if he wasn't going to use them, he could store them in one of the 3 sheds, but to not throw them out. Today, October 3rd, he sends me pictures saying he cleaned up the yard, and I see that my apple tree in the front yard is missing, and the choke cherry tree in the backyard is also missing. He did not have permission to cut them down. I explained this to him, and he says, I did not touch either of the big trees, any more than I showed you a couple of months ago, and you had no problem then. If you were not happy, I apologize, but you told me to deal with the yard, so I dealt with it, so that I was happy in the way the yard looked. Sorry we didn't know the tree in the front yard was to stay. We checked it, and it hadn't produced anything. We pruned the apple tree end of last summer, so of course it won't produce apples this season. Now he's trying to get out of his lease by telling me to evict him, but I want repayment for my trees. It was stated in the lease that they weren't allowed to remove any permanent fixtures pertaining to the property without written consent from us. What can I do? Are the tree stumps still present, or did he possibly sell the trees? Tree stumps are in the photos. Just a question then, is it possible to value a tree from its stump? It will give a good estimate as to the size of the tree, given the circumference of the stump, as well as being able to count the rings to determine its age. An arborist can go off a stump to appraise the loss. I suggest contacting a property lawyer immediately. Trees can be very expensive. Then, file eviction paperwork and a lawsuit against the tenants. I am not a lawyer. Additionally, a local lawyer can keep an eye on the property to make sure this person doesn't trash the place any more than they already have. In BC, Canada, rentals are regulated through the Residential Tenancy Act. The Residential Tenancy branch handles all disputes between the landlord and the tenant. Based on your statement, you have contravened the Residential Tenancy Act by including terms in the rental agreement/lease that require the tenant to perform duties that you are legally required to perform. You cannot contract out of the law. The Residential Tenancy Act clearly states that landlords are responsible for all maintenance, including lawn care. You can file for arbitration, however, it's very unlikely it will go the way you want. It's also possible that you could owe the tenant damages. The tenant has also done damage, and the arbitrator will consider that against what you may owe the tenant, if anything. However, they are unlikely to assess a high value. You are wrong, actually. BC Tenancy Act says tenants are responsible for lawn care and snow removal. Property maintenance. 1. The tenant must obtain the consent of the landlord prior to changing the landscaping on the residential property, including digging a garden, where no garden previously existed. 2. Unless there is an arrangement to the contrary, where the tenant has changed the landscaping, he or she must return the garden to its original condition when they vacate. 3. Generally, the tenant who lives in a single-family dwelling is responsible for routine yard maintenance, which includes cutting grass and clearing snow. The tenant is responsible for a reasonable amount of weeding the flower beds if the tenancy agreement requires a tenant to maintain the flower beds. 4. Generally, the tenant living in a townhouse or multi-family dwelling who has exclusive use of the yard is responsible for routine yard maintenance, which includes cutting grass and clearing snow. 5. The landlord is generally responsible for major projects, such as tree cutting, pruning, and insect control. 6. The landlord is responsible for cutting grass, shoveling snow, and weeding flower beds and gardens of multi-unit residential complexes and common areas of manufactured home parks. Someone copied the law above, noting that unless it is a multi-unit residence, i.e. apartment, that's incorrect for single-unit dwellings. the tenant is responsible for lawn care, but not removing or pruning trees. And Alice in Canada Land says, I'm going to add my voice to those suggesting you cut your losses and get this guy out as soon as you can. He's been consistently late on rent and is clearly ignoring you. I'm worried that he's doing damage inside the house or will be soon. It's not going to be easy to get him out, given that he has a 2-year lease. If a lawsuit over the tree gives you a card to play during any negotiations, then it may be useful, but I don't think you should expect to get the value of those trees from him. I doubt he has the income or assets to pay you. In all of this, and especially as you're 10 hours away, I urge you to find a lawyer or paralegal to help you file the proper paperwork on time. In Ontario, paralegals are regulated and allowed to appear at the Landlord-Tenant Board. I'm not sure if this is true in BC. Here's the BC Residential Tenancy Act, which will have more information about your obligations and the proper course to take to evict this guy, and there's a link for that one. In addition to call an arborist, also call around for local tree trimming companies to find out who did it. Cherry wood can be very expensive and is used for fancy cabinetry and furniture. Your tenant might have sold the wood, which would have been theft, an actual crime. It might help you in evicting them. Well, like I said before, there is not an update for this one, so I'm gonna guess that OP took that advice and went well. I hope you guys enjoyed this one. I'm gonna throw you to outro Markee now. Alright guys, that's all for today's episode. I hope you enjoyed it. If you did, be sure to tell me what you thought about it down in the comments down below. If you're new to the channel, also don't forget to subscribe. It would really help out with my channel growth. And also, a huge shout out to my channel patrons and members. I just love you guys and thank you for supporting me on this journey. If you guys are new to the channel and you'd like to support me, links are down below for the Patreon, or you can click the join button next to subscribe if you'd like to become a channel member. Alright guys, that's all for today's episode. I hope you enjoyed it. I hope you have a good day, night, sleep, whatever you're up to, and I'll see you in the next episode. Bye.